Okay, so here we go, after lunch.
We are back, and the appearances are as before, with the jury absent. And anything before we start?
There is, Judge.
What's up?
Jury absent. Obviously, somebody's making some sort of motion or doing something, or they would have. They already know this.
Judge, I'm at the lunch break. I had done some research, and at this point, the defense is going to be making a motion for a mistrial. However, that motion is going to be requested with prejudice.
Okay, when they make a motion with prejudice, that means anytime they pick a jury, it's what's called jeopardies attached. The defendant is being judged, and the state only gets one bite at the apple. So if you dismiss a trial in the middle after jury has been picked through usually prosecution misconduct, you get a mistrial with prejudice, meaning he can't recharge him. And that's a way to punish the state for doing shit they shouldn't do. And it's a good thing. Most judges will not give a mistrial with prejudice. They will either give them the option of saying, I'll give you a mistrial, but not with prejudice. I'm going to give the DA leeway to refile. Now, this would be great right now if the judge said, yeah, I'm looking at how long this thing is, so I'm pretty sure he didn't say yes. But anyway, I wouldn't expect him to say yes anyway. He doesn't care. And, attorneys do this now that it's on the record. If this goes to appeal and an appellate judge says he should have got a mistrial and he was entitled, it's on the record. So that's what this motion is.
I'm aware that the court's aware that normally a defense motion for a mistrial does not preclude a retrial. I understand that. There are exceptions to that, however. And the case that I am drawing this from is Day versus State. It's 76 with 2nd 588. And what it says is, an exception to this rule exists where a defendant's motion is necessitated by prosecutorial impropriety designed to avoid an acquittal. Now, what has happened in this morning?
So what that means in layman terms, designed to a mistrial, designed to stop an acquittal. Meaning, if a DA feels he's done such a shitty job and he's completely losing his case, he will cause a mistrial because he knows he's going to lose it, and if he gets an acquittal, he can't recharge him. So I will do things as a DA because I'm a crooked piece of shit working for the government, and I will do something that creates a mistrial, and then I get to refile and I'll recharge his ass. And now I know their tricks, and he's been on the stand. I've got all this new information, and we'll just spend all the taxpayer money to recharge him. So it's a trick and a loophole for the government to get around their dishonest behavior. The whole purpose of dismissing a case in a mistrial is to punish the offender. So, and right now the DA is the offender for this mistrial. If the defense did something that really pissed off him and he's like, you know what, that's going to blow my case, there's no way they're going to convict, I'd rather start over, he could ask for a mistrial. When he asks, jeopardy always attaches. He'll never get, it doesn't matter whether it's with or without prejudice because he gets to refile. He's requesting it. Anyway, here we go.
Morning was 2 times. The state had commented on Mr. Rittenhouse's right to remain silent. The first time he was admonished by the court. The second time...
You notice the DA is not looking at the court. He's not looking at them. He's acting because he knows he's on camera. He's like, whatever, I don't care. Say your shit. The judge ain't gonna do it. If he does do it, I'll appeal it. We're gonna charge your client. Your client ain't walking just because you want to do a mistrial. See, DAs are so unaccountable, they really don't give a shit. Even when they lie, cheat, do things they don't care. They have immunity. They're protected by the government. Nobody's going to charge a sitting DA. The only person that can charge a DA is the state's attorney, the state attorney general. They're the only ones that can bring charges, and they don't do it. Never. I mean, I can't even remember the last time a DA was actually charged by the state attorney general. I cannot think of a case. So why should they give a shit what they do? Why should they follow the rules, and why should they care? They don't, because they're unethical, power-hungry lawyers.
The court had the jury leave and re-admonished him on that. Prior to Mr. Rittenhouse testifying, this court addressed various things with not only Mr. Rittenhouse, but with the lawyers. You had cited various statutes, and then you had asked if anything would be coming up on, for example, I think 90608.
And most of y'all, there have been a lot of trials. There's usually a request for a mistrial, and I'm going to say 75% of trials, one side starts talking about a mistrial so they can get it on the record that they think they're getting a bad deal, so they can set up an appeal, so they can, play the victim, whatever. So this isn't like, oh my God, this happens all the freaking time, people.
Wait, one of the other things you addressed was 90404. And you had said that based on the information that had come out at the trial, nothing had changed as it relates to your ruling. Shortly thereafter, Mr. Binger stated, and we looked it up.
Also, what they're doing now is they're getting all this on the record. They're making a record of this for appeal in case the appeal is kind of close, or it may not be. The appellate court will be reading this and figuring out that the DA was acting inappropriate through the whole time. So if it's iffy on the appeal, the appellate judges may rule against the DA for this shit and, grant the appeal. But
previously, he said to Mr. Rittenhouse, previously indicated that you wish to have your AR-15 to protect someone's property. Clearly in violation not only of the prior ruling that you had made, but the ruling that very day, that very morning. It appears to be that there are two really elements the court must consider when making a determination on a mistrial for what amounts to prosecutorial overreaching. And the first one is the prosecutor's actions must be intentional in the sense of a culpable state of mind, in the nature of awareness that his activity would be prejudicial to the defendant. I would argue to you that that's clearly aware of that. You had warned him, you had told him prior to Mr. Rittenhouse testifying that these things, certainly the 90404 was off limits. You had warned him about the infringement on his constitutional right to remain silent. He did it again. The second one, I think, requires some action by the court in terms of a finding. The second one says the prosecutor's actions was designed to allow another chance to convict. That is, to provoke a mistrial in order to get another kick at the cat because the first trial is going badly, or to prejudice the defendant's rights to successfully complete the criminal confrontation at the first trial. Now, the case that I had cited is a Kenosha case, State versus Coping.
Opening?
Yep. 100 with second, 700.
COPENING?
Yes, sir. In that case, the court didn't make findings regarding the prosecutor's actions.
And anytime they say the court, you might have figured it out by now, that means the judge. The judge is the court. When you go against the court's ruling, you went against the judge's ruling. So the judge is the court when they're talking.
So I don't know that it's my role to sit here and say who's winning. I don't think that's necessarily what I'm supposed to do. But I think the court has to make some findings as it relates to the bad faith on the part of the prosecution. And if the court makes a finding that the actions that I had talked about were done in bad
That's the judge's phone going off in his own courtroom.
faith, then I think both elements for mistrial with prejudice have been met. And I think under the circumstances, based on what I've put forth on the record, I would certainly ask the court to consider those. And I would ask the court grant the motion with prejudice. Thank you.
Thank you. State?
Your Honor, I would like an opportunity to more fully respond to this with a little bit of research. At first blush, though, and I reserve the right to present case law and additional cites to the court, but I do want to point out for the record that the defendant has presented interviews to at least one media source and at least one online source since his arrest. And there have been questions about that night. There have been questions about what he did, things like that. He has decided, probably on advice of counsel in those circumstances, not to give a statement in the media about what happened. But he is talking about his family life, he's talking about his friends, he's talking about the circumstances of the case, he's talking about how this has affected him and things like that. So my point in asking those questions was, you have agreed to talk to the media. You've agreed to talk about yourself.
You didn't say that. You didn't say that when the judge was chewing your ass, and you didn't say it at any time. You said it after you went to lunch and came up with a good excuse that you could use that you think would work. A typical weasel DA move.
You've agreed to give interviews, but until now, this is the first time you're explaining your actions. And so I wasn't referring to his in-custody statements. In fact, I never asked either detective about what the defendant told him. He actually starts to tell them some things, and then he says he wants a lawyer, and they stop him. And they Mirandize him first, by the way. Then he starts to tell them some things, and he says, but I want to talk to my lawyer. And they're like, okay, we're done. So I'm not referring to that. I didn't ask any questions of the detectives about that. But since this, the defendant has spoken to the media. He has talked about his life, about circumstances related to this case. He just hasn't given his exact version of events that night. So his voluntary discussion to speak to the media has nothing to do with the Fifth Amendment. That is his own decision. And if he's going to pick and choose what he wants to talk about in those voluntary interviews with the media, then I think that's fair game. It doesn't implicate his Miranda rights. It doesn't implicate the Fifth Amendment. He's making his own voluntary choice.
Well, wait a minute. You don't think he could give an interview about his awards he won in high school, or his demerits that he got, or his and about his sports activities and his swimming and that, and declined to answer any questions about the incident in question, and that somehow a waiver of his right to silence?
I think he's doing more than that, Your Honor.
Well, here's where the judge is going. Your Fifth Amendment rights guarantees you the right to remain silent and not provide evidence against yourself to the government. When he's giving interviews about his family life, he's not giving an interview to the government. The government is not questioning him in violation of his Fifth Amendment, and he's not waiving his Fifth Amendment rights just because he talks to the media. He's trying to make that confusion, but that ain't true. I can talk to the media and not talk to the government. The Fifth Amendment doesn't say if you don't talk to the government, you can't talk to anybody. That's not what it says.
In these interviews.
I don't know. I knew nothing about them. I never, I haven't seen I haven't seen probably 1% of all the evidence, which is pretty typical, as you know. So I have no way of knowing it. You have some interview.
It's thundering outside in case you're hearing that.
Some interviews that he gave to media or to whatever.
Yeah, there's an interview that we're looking at on our computer right now from the Washington Post, where he talks to them. I know there's one, I think it's either the New Yorker or the GQ magazine, where he speaks to the reporters also. And he doesn't go into specific details about what happened.
Your Honor, when did the defense find out about this? Because this wasn't discovered to me because they just found out at lunch. So it wasn't discovered, which tells he's being more unethical. That's why he's exploring this, which isn't true. He didn't mention a damn thing about an interview in that trial and when he was getting his ass chewed. And if the defense lets him get away with this, then they're a fool.
Happened that night, but it's not like it's talking about school or swimming or things
well,
like that.
No. Just don't leave it at. He doesn't go into specific details. I mean, it's certainly there could be a waiver, but a very modest discussion about the activities of that night. And if you're suggesting that occurred, that could make a big difference. But even a small.
That's why you don't give interviews and you don't talk.
Discussion on his part of the night in question might be a full waiver. I don't know, but I won't know until I see it. But why don't you make copies of it and?
Can we have a few minutes to hear
well,
answers?
we won't do it right now. I do agree with you that this is not something that I would want to do sitting here without giving you an opportunity to respond. Although I would be interested in your preliminary response to the excluded evidence that you touched on after having been told not to do it, or having been told that I was confirming my prior rulings.
I do want to just point out right now, we've got it on the screen. This is a Washington Post article, and there's reference to an interview that he says, the defendant says, he did not regret having his gun because, quote, I would have died that night if I didn't, end quote. So that's a direct quote from the defendant to the media about that night.
What about that?
Your Honor, all I can say about that interview is there were prior counsel representing him.
I don't care about that.
Well, and I believe it was a telephone interview. I don't know anything about the circumstances of that. I'd have to read the article.
And the article isn't necessarily proof that it happened. You need to have who wrote it, who did he talk to. You'd have to subpoena that person. You just can't bring up that he said something and then don't have anything to back it up. You have to get it in.
Oh, that might make a difference. And what about the you're asking questions about excluded evidence?
Your Honor, we went over this earlier, and I don't want to repeat myself because I know you've heard me, but if I could just summarize. I did hear you talk about that evidence this morning before testimony. The defendant then took the stand. He admitted that he had said to the person in the yellow pants that he had pointed the gun at that person. I have seen that video. It was actually introduced by the defense. I think it was even in their opening statement. And there's this person who confronts the defendant and accuses him of this. Frankly, to be honest, Your Honor, when I watched the video the first time, I didn't hear the defense reaction. I thought it was someone making an accusation and then the defendant walking away as if trying to avoid a confrontation. I was surprised to hear the defendant admit in his testimony, on direct, by his attorney, that yes, I did tell that person that I had pointed the gun at them.
One little statement opened this up. One little interview. Man, I'm telling you, man, when you got the government after you, you have to go into hiding.
He explained then that he was joking when he said that. The jury can evaluate that. It goes to his credibility. It goes to whether or not he's telling the truth. It goes to his decision making. That is, again, this is an incident that occurred that night, so it's not something that happened separate in time. It presumably happened a few minutes before. But like I said, I was taken aback by the defendant admitting that he had said to this person, yes, I pointed the gun at you. And I think it's fair to say that.
Nice case. You never interviewed Yellow Pants? You didn't watch it. You got all these people slowing down videos, drawing all over them. You didn't have the audio secluded so you could hear that reply?
Watching that video, that person, believes strongly that this happened. The defendant is telling him it happened. Now the defendant today is giving us a different version and saying, oh, I made it, I was joking, I was just kidding that guy or whatever. I'd like to probe that. I'd like to probe what he said to that person. I'd like to probe what his motivations were, etc. I'd like to probe whether, in fact, he really did do that. And I think that changes the equation with regard to the CVS video that was the subject of the other acts motion. Because in my mind, it is very similar. And I know we've disagreed on that, and I'm not going to belabor the point, Your Honor, but that was where I was coming from, was there's been a change in the...
When did you find out about the Washington Post interview, and why didn't you discover it, and why does the defense not have a copy of it? I'll tell you why. Because they just found it during lunch, and they found a way to weasel it in, and now this lying piece of shit is lying to the judge in court about that's what I was talking about when he just found out about it at lunch.
The testimony of the defendant today that I think makes that evidence, it's admissible and much more relevant than it already was, and I thought it was already relevant. And the court is... I do want to be clear
So
also...
I'm just here on the sidelines, just to...
Well, you...
Yeah, I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute... We've had 3 state motions in the matter. There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear, that is not coming in. There was...
Don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just take it upon yourself to put it in because you think that you found a way around it? Come on.
If I may finish, Your Honor, I was about to say, your ruling on our 3 motions and other acts motions was there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things.
No.
So I saw that.
You left the door open, meaning your ruling wasn't clear, meaning you don't know what you're doing, Judge. I'm smarter than you.
Distinction. I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming.
So another thing this lawyer's doing right now by doing this little tap dance is he's preventing the bar or someone else to say he intentionally did this. I said on the record, I interpret it differently and I didn't think I was doing anything wrong. I was just exploring it. So now they can't get that he intended to ignore the judge's ruling, therefore nothing's done.
In, and I have practiced before you, Your Honor. I have filed other motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion.
I undoubtedly did.
So I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you.
He just called him a fucking liar. I love it. I fucking love it. And you know what? I don't believe him. And if I was the defense over there, I'd be like, Your Honor, not only did he do this, which was flagrant, we had another witness testify that said he tried to show him a video and tried to get him to change his statement. And for y'all that don't know, that's highly inappropriate for a DA to be involved in an interview. DAs are not supposed to interview witnesses because then they become a party to the action. And when he interviews a witness and shows him this, he can now be subpoenaed for that action. And you can't prosecute it and be a witness to the action. So he was totally wrong in showing that video to that kid. You know it was wrong. It was unethical. It was witness tampering. And he was trying to get this kid and let him know that when you testify in front of me, remember this guy's name. So when I ask you, do you know who this is? You'll say yes. And nobody needs to know that I showed you this. It was unethical. It was crooked. And he got away with it. And now he's doing this. He's just a dirty DA. I mean, look, any experienced DA, they know how to play the game. And he knows how to play the game. He's crooked. It's a game. He doesn't care who he puts in jail, how many innocent people. You saw him attack witnesses. He doesn't care about destroying witnesses. He called that woman, didn't know, what did he say? You carry a gun? You think you need, he insulted her. I'll call her racist because, they yelled Black Lives Matter and that intimidated you? So he implied that she was a racist. I mean, this guy will go to no ends to destroy anybody's life for his little game to win.
There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith. All right. Would you come up, please, Mr. Rittenhouse?
God, come on, defense. When did you find out about that interview? He can get that interview knocked out now because he lied to the judge. I guarantee you he just found that at lunch. And he said, that's what I was going for. You're full of shit. You didn't know about it till lunch. And if you did know about it before lunch, you violated discovery and you didn't give exculpatory evidence to the defense team. So you lied either that way or you lied that you had it before. What a freaking liar that DA is, man.
I do have,
Yeah.
Your Honor,
Yeah.
I do have another item that I want to raise before the jury comes in and raise it with you. There was another ex motion with regard to the defendant being at Pudgy's bar after a court appearance in January in which he poses for selfies wearing a shirt that says free as fuck. I would like to ask the defendant if he posed for selfies after a court appearance with members of the public wearing that shirt. I do not intend to talk about who those people were, what groups they were affiliated with, or anything along those lines. But I believe that it is relevant when the defendant goes to a bar after a court appearance and poses for selfies wearing a shirt like that. I think it is relevant to some of the issues that have come up in this case. For example, his remorse or lack of remorse, his utter disregard for human life.
How do you know free as fuck means he's talking about the criminal trial and it's not just being a free American? I could wear a shirt free as fuck and I'm not facing any charges. Is the DA going to claim that I'm somehow thumbing my nose at the court and I don't care? You're a freaking idiot.
Those are things that I think it comes into play because I think that behavior is not consistent with someone who has a regard for human life. The jury's already watched him break down on the stand with emotion. I'd like to probe how heartfelt and sincere these emotions are when you
See, he wants to attack the emotions. I knew that was coming. He's going to try and stick it up. And, oh, you were crying then. You weren't crying now. You weren't crying when you shot him, did you? You didn't cry when you killed so-and-so. You didn't cry when you killed this person. You didn't cry when you blew the arm off so-and-so. That's what he wants to go for.
You go to a bar and you pose for selfies with people when you're out on bond in a first-degree intentional homicide trial wearing a free-as-fuck shirt. So, as I said, I want to use the photograph. I'm not going to talk about any of the people or who they were from. In fact, the photograph I'm going to use has actually got their faces blocked out, so we won't see any of the people in the crowd. We'll just see the defendant standing with a group of people for a selfie with that shirt on. That's as far as I want to go.
Handle this issue.
Nobody got an opportunity. First of all, you've made a ruling on it, and it was clear prior to him testifying. So part of this is, would we have raised it? Would we have brought it up if we would have known that it was going to be coming in? We have done there's been nothing to open this door, Judge. Nothing that has been said to open the door about what happened 4 months after this is relevant in any way to what happened that evening. That is part of what the court had ruled. You had said 4 months after, I don't see how that goes to any 90404 type of admissible evidence. So my argument is
That's a good point. If they as a defense team made a conscious effort to put their client on the stand based that this information wouldn't come in, and now the judge lets it in, they can't pull their client off the stand now and go, wait a minute, if we'd have known that, we wouldn't have put him on a stand.
you ruled on it previous to him testifying. You confirmed your ruling, which you had made previously, where Mr. Binger just said you had shut the door on it. So apparently he doesn't believe a door that is shut should stay shut. However, now he's asking that something be admitted that, to be fair, this should have been brought up sooner. This jury, I did the voir dire, I would have voir dired on an issue of whether or not they heard it, saw it, were aware of it. How they felt about it, whether it had an impact on their ability to be fair in the case. We never went there because of your prior ruling. So there's nothing that's opened this door, and I don't think it's relevant, something that happened 4 months later. You talked about indifference to human life. That's that night, not 4 months later. There's nothing that's relevant about that. You've
That's a good argument. I think he did a good job here.
already made your ruling. I ask that you stick with it.
I'm struggling with why it would be relevant to any of the issues in this case. If he were on trial for using exquisitely bad judgment, if he were on trial for behaving in a very offensive way, then I could see the purpose.
So what the judge is doing now, for y'all that don't know, is he's justifying his ruling that he's thinking reasonably, and this is why he's ruling, and he's getting on a record. So if the DA goes and cries later, that the court reviewing the transcript will see what the thought process was of the judge on why his ruling and say that was reasonable.
But an incident that occurred 4 months after the incidents in question, I don't see how that jury can work with that in reaching any conclusions about the issues in this case.
First of all, Your Honor, we have introduced evidence that the defendant had a slogan on his TikTok page, "Bro, I'm just trying to be famous." This case has made him famous, and he's posing for selfies as a result. One of our theories of this case is that his behavior that night was intended to gain attention, to be famous, and he's reaped the benefits of that. Second of all, he is...
This is why when you get your client on a stand, the DA will stop at nothing at trashing. I mean, and you can't control them. I mean, it's just, they're going to get something, I guarantee you.
on trial, in my opinion, for exquisitely poor decision-making. Taking a gun that he's not legally entitled to have, coming down in violation of curfew, running around the community with that gun, trying to be a police officer when he's not, confronting protesters that he knows are hostile, and...
Maybe if the police officers were being police officers, which they were getting paid to be, you wouldn't have to have citizens arm themselves and protect their property. Maybe that, Mr. Government DA, you got no problem defending your cops when they're out there shooting up the neighborhood and they do mag dumps and they shoot 50 rounds in a car at a person that wasn't even armed. You got no problem with that. But now you got a problem with this kid trying to put him away for life. God, this guy's a piece of shit.
all of those behaviors, I think, are exquisitely bad judgment. So the jury can make that decision. The jury can give what weight they want to this evidence. But it's moments after he has a court appearance here. He's out on bond in this case when he decides to do this behavior. And nobody made him do it. Nobody forced him to go to the bar. Nobody forced him to wear the shirt. Nobody forced him to post.
Look, I got no problem with that being bad judgment. And he's stupid for doing that. I blame the people that weren't advising him, or I blame him if they did advise him and he ignored it. I mean, he doesn't realize the jeopardy he's in, and his whole life's about to be over. He's a young kid. Young teenagers don't see around corners. They act spontaneously and just say and do things. We all did it when we were young. Doesn't mean he should spend the rest of his life in prison.
For selfies, it's his own decision making.
When I made reference to exquisitely poor judgment, I was talking about at the incident when he was wearing the shirt. Because everybody in all of humanity, at one time or another, displays bad judgment. Sometimes exquisitely bad judgment.
Yep.
And we don't let it into people's trials on unrelated matters. So I wasn't referring to his having had good or bad judgment on the day in question. That's a legitimate inquiry, and you're being allowed to present a lot of evidence on that subject. And the jury is going to be instructed on in some of the element of some of the crimes that are charged here is going to deal with the caliber of his judgment. But you're talking about an incident that occurred 4 months later. So I'm not saying it, and I don't want to waste any more time with it. I don't think that I've ruled before it's not admissible, and I have heard nothing to change my mind about that.
It was sought to be admitted earlier for a different purpose, Your Honor.
I'm sorry.
It was sought to be admitted earlier for a different purpose than it is today. The court has ruled that it can't be admitted for the prior purpose, but I'm seeking to introduce it for a different purpose today.
And that request is denied.
Thank you.
Okay? Are we ready to go?
Man, it's pouring down, not raining. I don't know if you guys are hearing that, but it's pouring.